Welcome to Estate Planning Weekly. I'm your host, Bill Gross, at Bill Gross on social media, at Bill Gross Probate on social media. And here on Estate Planning Weekly, we interview attorneys, often attorneys who do estate planning, attorneys who, I think I might say, preventative estate planning, after the fact problem cleanup, which is estate planning litigation, and vendors to support us. Today, I'm excited to have a local friend, somebody who I've talked to over the years who does estate planning. He also does litigation, so he can give us some unique insights. Liran and Aliav, thank you so much for joining us today.
I'm happy to be here.
So let's talk about estate planning. Though I do know you do litigation, but as a result of that, you see common mistakes or areas of attention that litigation kind of attracts. What would you say are one or two of the areas that most commonly either are mistakes or areas that need to be avoided or protected against in cases of estate litigation and to protect your wealth and assets?
What I see a lot these days from the litigation standpoint is you have these trusts that are usually made online or a form of some sort, and they're missing key provisions in case of contingencies. Most of the time, it's in case of the contingencies. And because of they don't have the contingency, we now have to go to court and ask, what was your intent, and what would he have done, or she? And that itself is a big problem. When you have a attorney drafted trust, you usually avoid those contingencies. Not saying that attorney-made trusts don't go to litigation. They often do, but it's more with the lack of information in those forms. People think that they could, use AI or go online and just get a form and change the names and call it a day. A lot of times that's not the case, and it ends up costing the family dearly.
So it's interesting that you say it like this, and you've been a guest on my other podcast, Probate Weekly, and not as an attorney, but just as a businessman, I tell people that 90% of the time, you're better off with a bad trust done online, one of these online services, than nothing. And here you're probably pointing out that these online services, you get what you pay for, and if you get something that's very expensive, you're going to get a very limited set of circumstances. But I always feel like from a salesman point of view, if a customer at least has a bad trust, they can take that to a proper estate planning attorney, and so like you can look at that and say, okay, well, thank you for identifying these issues, but and then you would ask the questions of those contingencies and create what I would call an appropriate trust for the person. So it's interesting to hear you say that's the area that you focus on is the contingencies. So let's talk about that. I think one of the contingencies I see often litigated is the successor trustee, right? When the trust is made, initially it's the person who comes to get the trust written, and then they nominate one or two people, and those people over time either pass or don't want to do it. Is that one of the most common contingencies that people haven't prepared for?
Yeah, absolutely. There's, just in my trusts, you have a clause that says if all of them pass away, there's a way to appoint a successor trustee without going to court. And that's invaluable. Something that many of the online trusts don't have. Obviously, you could add it. And you brought up the point of, hey, why don't you get a form? It's good for you, at least 90% of the way or whatever it is, and then go to the attorney and end up putting in the rest of the 10%. The 10% that you would add with an attorney ends up being the most important 10%.
Yeah.
Let's say, I'll just give you some numbers here, right? Let's say you get a form online, or you hire LegalZoom or whatever it is, and you spend, I don't know, $900 on a trust, right? And you're saving, let's just say, a couple $1,000, which is great, fantastic. You save that money. Now, if that trust lacks something and I have to go to court, the minimum retainer for my fees is going to be $5,000 minimum. It could be a lot more for that.
A lot more. It can end up being a lot more.
Right. It could be 10,000. I mean, it just depends. Is there someone objecting objecting on the other side. If there's
Right.
someone objecting on the other side, you
Right.
quadruple, quintuple it, whatever you want to do.
Right.
It's just going to be a lot more.
Right.
So yeah, you saved a little bit of money in the beginning, but you created a huge mess for your heirs. And sometimes it works. I'm not going to say, hey, every single trust is bad, and you might be right. It may work, but people don't like to go to sleep knowing that their estate may work. That's something that I would not be able to live with if I had to go to sleep as a non-attorney. Okay, well, I may have it done properly. That's not good. I want someone stand behind me. If there's something wrong, the beneficiaries could come to the attorney and go, hey, how come this occurred? Or how come you wrote it this way? And the attorney could fix it and stand behind his documents and ultimately give the family peace of mind, which is really what you're after.
Well, I don't mean to diminish the value of your service. The opposite. I think in those cases where there is no need for contingencies, at least they have something better than going to probate court. But I think you're correct that the problem is it's never a problem until it's a problem. And then once it's a problem, it's a problem. And I think that's the challenge of this whole process. The other part is I saw a statistic that over 80% of online trusts are never funded. Or are even executed probably, is also probably true, but not funded. And so as a real estate agent, what that means to me as a real estate agent and those listening is that I literally have a client, an estate, a $40 million estate. They have $30 million of real estate and real estate related assets. And the decedent had gone to an estate planner several times, had written a big check, and it has a great binder, but never executed it and never put the property into the estate. Therefore, we're in probate court, and at best, his documents are an indicator for the court. But even there's a contested because it's a will that's not in this package. So let's talk about the importance. I think one of the things I like that you're local, for me at least in Beverly Hills, is that people could go see you or see you in person. But how do you make sure, and what can you do, because ultimately you'll control your customer, to make sure they end up leaving your office and executing the plan, and then additionally putting the assets in the plan so what they paid for has effect?
Okay, that's a great question. Essentially, you're asking me, how do I make sure that the trust is funded? And when you create a trust, I always say to everybody, it's a bucket. It's a bucket that you have to fill up with all of your stuff. And if it's in that bucket and you pass away, then it goes by whatever you wrote in your trust. And it goes by without the need for court interference. However, if it's not in the bucket, or you've taken it out, a lot of times people just take it out to put it to get a loan or a refinance, or because their child told them to put their names on it, whatever it is, they take it out. And now it's not in the trust. Now we have the burden to somehow go to court and petition and say, hey, you meant to put it back in the trust. Right. Now, that's different than if I create a trust and you forgot to put the property into the trust the first time. That's a little bit easier. But when you take it out, now I have to find your intent post you making the trust of whether you really wanted to put it back in, which is much harder and usually doesn't fly in the courts. It is a fact-intensive question of whether we can even put it back in, and now you have to pay for that to put it back in, which is going to cost you way more than the estate plan in general. So,
and probably more probate. By the end of the day, the funny people say, "Oh, that's not a big deal. We just have to do a such and such Hagstead petition is the term we use in California for that petition." But a Hagstead petition can cost you more and take longer than a probate. It's not like it's a magic pill. It's still a process and costs money and time, effort, and energy.
Right. If it's uncontested, it might be faster. But if it's contested, it's probably takes longer. But back to your question, which was the main point, is how do I make sure the trusts are funded? I am not going to just make you a bucket and do nothing. Right. So we're going to move the properties before you leave this office into the trust. And we're not only going to move the properties, we're going to move your partnerships and your corporations. All of those, a lot of people forget, need to also be in the trust, right? And many of these real estate investors have almost all their properties in LLCs. And they go, well, yeah, I have LLCs, I have a trust, I'm good to go. Well, did you put the LLC into the trust? That's a huge question. And that could cost the family a bunch of money at the end of your life, because those are not funded into the trust, and they have a special way. Every asset has a different way of getting into your trust. I can't just put a list together and call it a day. It doesn't work that way. I have to call banks. I have to record deeds. I have to draft documents to move assets like LLCs into your trust. So all of that is highly important when you're looking for an attorney, whoever it is, that they do all of that, and they include that in their service, which is included in our fee. It's not an additional charge. It's if I create a trust for you that doesn't work, then I failed, right? If I create a trust that doesn't avoid probate, then what's the point of it? Well, what did you pay for, right? So that's our promise to our clients, is we make sure that you're going to get a deed in the mail. It tells you it's in the trust, whatever it is. It's all in that binder, where it's all taken care of in terms of funding.
As a real estate agent, when I refer people, I always follow up, because I can check on public records, did it happen or not? And I feel like Liran's attitude there is, I can't argue with the legal side, right? Some attorneys say, I don't want to take responsibility. I'm going to give you some instructions, and you need to transfer the deeds, and you need to transfer your bank accounts, and I'll give you a list of all things you have to transfer. To me, as a businessman, that's not satisfying the customer's problem, right? The customer didn't come to you just for legal advice. He came to you because he had a problem. I think legal advice is a component of it. And so from a business point of view, I would say if the attorney's not willing to follow through and get the bucket filled or fund the trust, and that includes not just preparing the deeds, I mean, it's getting them recorded, making sure they get recorded, the bank accounts, getting the title transferred, and verifying that. To me, that's the differentiation between somebody who's really serious about doing their customers' work and people who are just looking to get paid for legal advice. And I know there's different opinions on that, and I can respect other people, but the way I do business is more like that. My customers come to me to solve a problem. So thanks for laying that part out. Let's talk about one of the other key things is that I find as a problem is they do a trust, but somehow when the CEDA passes, nobody knows where it is. And so I get this problem regularly as a real estate agent, is the family come to me and say, well, the property is deeded into trust, and we know what he wanted to do with it. Of course, we just can't find the documents. We look through the house, we look for clues on the documents of who the attorney might be, maybe try to search the notary, figure it out. But we get to the point where we can't tell. And I also see in the LA Bar Association listserv chat thing where people say, anybody aware of a Joe Smith or whatever? So what happens in that case, and what can you and what do you do, if anything, to help customers avoid being I have the world's greatest trust, but I just can't find it when I'm dead?
Okay. You pretty much touched up on almost all the things that we would tell our clients to do. You go search around the house for any sort of evidence of any attorney, maybe even bank statements for your payments that you've made to the attorney, so that you could go and contact that person. The deed itself could give clues as to where to search, what attorney was involved. Maybe there's a notary, like you said, and you could go contact the notary. So there's a lot of ways to do it. But ultimately, if you can't find it after all of that, and with the listserv and everything, you just can't find it, now you're stuck in a situation where you might need to file a petition in court to quiet title. You might file a petition in the court to, based off of your other evidence, reconstruct a trust, right? If there's paperwork somewhere that shows what he or she intended to do, we could reconstruct it. It's a very hard thing to do. And worst comes to worst, we need to do a probate or usually a quiet title mixed with a probate. So it's definitely not a fun thing to hear. I cannot find the trust. Therefore, when you do a trust, there are some precautions you should take, and telling people where your important documents are, and not putting them in a safe deposit, because we don't have access to that without going to the court usually, which is kind of ridiculous if you think about it. I have to go to court without the document to get the document and then tell the court there is a document. That doesn't work out so well either. So you don't put it in the safe deposit box. Put it somewhere that they could find usually I tell people in a fireproof safe. I'm sorry, not a fireproof safe, a fireproof box that you could get on Amazon. Put it in your bookcase at home or somewhere that is easily findable. It's not a document that if someone takes, people think, oh, I have the trust, I could do everything. No, you don't. So it doesn't matter if people have copies. If you really, it matters if the trustee, the person listed, he might be able to do something. But a random beneficiary can't do anything with a deed or a trust just because he's a beneficiary. He or she is a beneficiary. So that's a misconception that I see. It's like, oh my God, they stole my deed from my house. What do I do? They're up to no good. They stole my trust. What could they do? It's not like they could magically move your property somewhere else now. If you really go deep and with all the crazy things that you could do, maybe they could transfer, I don't know, fake notaries, whatever it is. But at the end of the day, taking a deed or taking a trust isn't an issue.
So, I don't know that you know this. My father was an attorney, and he had a partner who did wills and trusts. Now, this goes back a long ways before you were born, when I was quite young. And I remember in their office they had like a vault with all the wills in those days, and then later trusts of their clients. And it was kind of expected in the old days that attorneys kept them. And then there was a time period when attorneys didn't keep them as a general rule, and for whatever reasons. And then now I see attorneys have different opinions. Some say, no, I never keep it. I always give it to the customer. And there's a reason. Some say, I always keep a copy for these reasons. And now with online storage, obviously there's a hybrid solution. So where do you stand on how do you handle customers' documents as far as making copy available for them, or do you store copy, or you don't, or you use online, or how do you help with that?
We store copies here in the cloud. The originals go to the clients themselves. They own all the originals. They have it. They get it. But most of the time, the copies are good for all the things that I need to do. The only time that an original is really needed is when you go to probate, which you shouldn't be if you have a trust. But if you need to go to probate because of some issue, you might need the original will. Not saying that you 100% need it. You could still file petitions based off of a copy of a will, as long as there's people who are not going to contest those wishes. It should be fine. But the original is, in my books, is with the client.
And I think it makes sense. And then having stored copies, I think, is also important in that if they can figure out that you're the attorney, they can figure out perhaps that you have a copy or access to a copy if they're the right person that could get a copy of it. And again, I think it gets down to not the legal right or wrong, but the business side. And I think it's important that we solve our customers' problems or prevent customers' problems where we can. And that, to me, makes a lot of sense. So you mentioned, because we tell this about mistakes in estate planning, you mentioned the lack of contingencies. What are one or two other mistakes or problems that you see in estate plans that lead to litigation that had they been written properly or written differently, rather than litigation, they just would have gone through the process of administering the estate, if anything?
The contingency dealing with who gets an asset if someone passes away. So it's kind of like the trustee where we don't know what happens after he passes away, but the contingency of, hey, you're going to get this property, but if you pass away before, where is it going to go? That, it depends. It usually says to their children, but what if they don't have children? Or what if the testator wanted it to go to a different person altogether? You might have litigation based off of that as well. Yeah,
I've seen where they designate say children, then children get married and have bad spouses who either get divorced or they never get divorced, but they're separated and everybody hates that person. And you have to wonder, now I can't get in the head of the decedent, but you kind of wonder, they probably, if they, in retrospect, could write it, they'd write it differently. But, it is what it is, and you're stuck, unfortunately, with what is. And I think a good estate plan will anticipate these kinds of issues. And that's why you go to a professional like Liran Aliav. So, Liran, look, I know I've kind of gotten here to the end of our time, and I appreciate I know you're really busy. You mentioned to me that you're actually looking for additional staff, attorneys on your litigation side, and paralegals to help you both with estate planning and litigation. So I really appreciate your time. It's always a pleasure. I always learn so much to talk with you. The website is aliavlaw.com, and right on there you have all the contact information. Contact us, register for a webinar. Tell me about, real quick before we run off, tell me about your webinar. What's the goal of that? What are you looking to help people understand who click on that?
That webinar is made for, it's kind of like an intro to estate planning. People will understand why and what they could do with estate planning. You just said the divorce thing. That's a big issue usually for your divorce of your children or your beneficiaries, not your own divorce, or your creditors of your children or the special needs of your children. Those are all addressed in that webinar. There is another webinar that we have that is for something called a land trust. And those it's an asset protection strategy. It's usually done when you want to be private about your name and who owns the property, and you just have a higher privacy concern. And those are becoming a lot more common these days. They may have other names for the land trust out in the open, but essentially it's a privacy trust of some sort. And that is actually what a lot of people are asking for these days. So that, especially in the highly litigious state of California, where people are just filing lawsuits left and right, and especially with the real estate landlord issues that you're seeing these days, where it's so difficult to be a landlord in the state of California, and attorneys are happy to know that there is a bank that they could go to make a claim against these days. So the privacy trusts do help in that situation. There's a mixture of things that we do together. There's management agreements. There's different kinds of LLCs that we set up from different states. All of that is geared towards privacy and asset protection.
So some of those assets, again, you should reach out to aliavlaw.com, hit the contact button, or book a call there, and you can get with him. People, the one big misconception I get from trust is they'll say, well, trust to avoid lawsuits. I'll say, no. Anytime you have money, there's going to be a lawsuit. A trust will help prepare you for the inevitable lawsuit or deter somebody at an earlier stage from continuing the lawsuit. But it just seems to me, I don't know, maybe I'm jaded at this stage of my life, wherever there's a lot of money, somebody's going to file a lawsuit about something, and you better have your ducks in order if you want to keep that or keep it for your family and your legacy.
Yeah, absolutely.
Anyhow, Liran, thank you so much for your time. I really appreciate it, and look forward to talking again soon.
Of course. Thank you.
And for the rest of you, again, this is Estate Planning Weekly. We get together every week, and we have a different episode with attorneys like Liran. Both attorneys do prepare estates, litigate estates, vendors that support along the process as well. If you like it, please like it, subscribe. If you have questions or something you'd like to see, feel free to reach out to me and let me know. I'm at Bill Gross Probate on social media. And as always, make today your best day ever. Thank you so much.